Today's presentation, first thing that we're going to pay attention to is regarding the public companies and investor relations. The most crucial information that you need to be aware of is that companies that have shares that are publicly traded on the stock market are considered to be publicly owned companies. Also, people who own shares of the company are called investors. The PR specialist whose work involves communication by publicly owned companies must comply with the Security Act of 1933 and Securities Exchange Act of 1934, which enacted in response to the Great Stock Market Crash of 1929. 1993 Act restricts corporate communication before and during the period that new securities offerings are being registered. In the meantime, 1934 Act regulates trading of securities after the initial distribution, requires periodic reporting about a company. The 1934 statute also created the Independent Federal Securities and Exchange Commission (SEC) to enforce the newly passed security laws, to promote stability in the markets and, importantly, to protect investors. Investment Company Act of 1940 and Investment Advisors Act of 1940 regulate investment companies and advisors. In addition, practitioners in this field are subject to the disclosure rules of the stock exchange that lists their company's stock. Just so you know that investor relations is also known as financial public relations. The practitioners are required to have in-depth knowledge of corporate finance, accounting, and law. Under the SEC's integrated disclosure system, corporations in which members of the public own shares must continuously provide information that affects the understanding of stockholders and investors about the financial position and prospectus of a company. Accordingly, practitioners must issue press releases, draft speeches, and write quarterly and annual reports to achieve the adequate and accurate information required under federal law. Public relations practitioners keep current with the changes in securities regulations by regularly visiting the SEC's website, which is www.sec.gov. Disclosure requirements take two forms, which is the Securities Act of 1933 and Securities and Exchange Act of 1934. Both of them mandate disclosure by senior officials of a corporation, defined as any director, executive officer, investor relations, or public relations officer, or other person with similar functions. It requires filings with SEC which the company need to provide material information about new security offerings so that investors can make purchasing decisions based on facts. Information is considered material if the information is likely to have a significant effect on securities prices, or if it is likely to be considered important by a reasonable investor when making decision to buy, hold, or sell shares. A company needs to register its stock with SEC to provide a detailed information about its financial history and prospects. A company cannot sell or buy a security before the security is registered with SEC. Some reformations of the previous acts lead to the Private Securities Litigation Reform Act of 1995, primarily in restricting such abusive litigation practices as routine filing of class action lawsuits against public companies following sharp drops in stock prices and abuse of the discovery process by plaintiffs' attorneys to extort settlement from publicly traded companies that might be willing to settle simply to avoid costly litigation. Additionally, the Act created a new safe harbor for forward-looking statements to encourage dissemination of information without fear of litigation. Companies may be protected from liability for predictions about earnings and performance, as long as such forecasts are tempered by meaningful cautionary statements telling investors why the projections might fail to come true. Appropriate disclosure procedure depends on the size of the company and the dispersion of its stockholder. But the basic principles remain the same, which is the public statements must be truthful. Securities regulations also prohibit fraud in securities trading, and it is necessary to show that insiders are using non-public information to help them trade securities profitably, or that insiders are tipping friends and clients with information that gives them an unfair advantage over the average investor. Insiders barred from tipping or trading on information not available to the public include corporate executives, public relations personnel, outside accountants, lawyers, outside public relations counsel, and other professionals with access to corporate plans. A combination of new federal legislation, Sarbanes-Oxley Act of 2002 and Securities and Exchange Commission and New York Stock Exchange rules implemented since November 2003, updated SEC regulations and further ensure compliance. The new rules increase transparency and timeliness, hold top management accountable for financial reports, and make sure insiders cannot exercise unfair advantage in either their compensation on stock or trading.
There are two types of law that are relevant to public relations: copyright and trademark. We will go one by one. First, copyright. To copyright work, the work should be a unique work of authorship that is constant in a tangible medium of expression. In simple words, the work is a concrete, visible, and most important, one of a kind. With copyright, the author can manipulate their pieces for a certain period, then it will become public domains, which means the public is free to use them. There are three goals of copyright: providing an economic incentive for creative people to produce their original work, for publishers to distribute those works, and preserve the general public interest by making sure that the right to utilize the works without regulation will in the end be handed to all people. There are 7 categories of works that can be copyrighted. Firstly, literary works. This can include novels, non-fiction works, poems, and computer programs. Secondly, musical works. This category includes both the musical notation and the accompanying words. Thirdly, dramatic, pantomime, and choreographic works. This type includes plays, operas, script, screenplay, and any accompanying music. But it does not include popular dance steps, for instance, shoot dance. Fourthly, pictorial, graphic, and sculptural works. This includes sketches, drawings, cartoons, paintings, and also photograph. For example, surprisingly, picture of the Eiffel Tower at night is protected by copyright. The fifth category, motion pictures and other audiovisual works like movies, videos, and film strip. The sixth category, sound recordings like recorded music, voice, and sound effect. Thunder, animal noises, and other sound of nature may be copyrighted by the person who record them. Lastly, architectural works created after 1990. Yes, some buildings can be protected with copyright. Next, there are 3 must-have elements in the copyright notice. First, the word copyright, or abbreviation CORP, or the symbol. Next is the year of the first publications. And lastly, the copyright owner's name. The fair use doctrine, PR practitioners can take a limited portion of the original work even before it falls into public domains. 4 factors must be considered. First, purpose and character. The work are permissible if it was used for non-profit educational purpose. Second, the nature of work. Creative works can be a bit restrictive. Third, amount. How much of the content was used. And lastly, market effect. PR practitioners should consider how it will affect the market of the work. Next, I will explain about trademark. Trademark is words, names, and symbols used by organizations to spot and differentiate their product and services. Trade name identify the commercial name of the producer. For example, Nestle manufacture Maggi, a trademark. Service mark differs from a trademark as it is identify a source of service, not goods. For instance, Grab is a registered name for a company that offers transportation, food delivery, and digital payment services via a mobile app. Trademark rights are created by adopting and using the mark on trade goods. Application for trademark registration can be filed before or after the patent is used in commerce, but usually after a commercial research firm has confirmed that no other party has registered the trademark. Trademark enforcement is limited to instances where there is risk of confusion or deceit. The Coca-Cola Company, for example, took issue with the link of its soft beverages with the word Coke, which stands for cocaine. Trademark owners routinely reminds journalists and public relations professionals that trademark should be used as adjectives rather than nouns or verbs. And lastly, in case of successful infringement suit, treble damage are available for the trademark owners. This implies that whoever infringed the trademarks must pay the legal owner 3 times the infringer earnings from using the marks, or 3 times any damage suffered by the legal owner, whichever is larger, plus reasonable attorney's fees to cover the cost of the trademark case. In addition, any item made with the infringing trademark must be given up and destroyed. Some examples of trademarks are products named like Coca-Cola and Pepsi, and brand names such as Proton and Proa.
Hello and Assalamualaikum, and I will be presenting about reputation, defamation and privacy. Defamation here is the legal term for wrongfully harming an individual's reputation, while privacy is an individual's right to be let alone. Both defamation and privacy violations in civil law are torts, meaning anything considered legally wrong that one party does to harm another. Now we move on to libel. Libel is a written defamation, where slander is a spoken defamation, which wrongfully harms an individual's reputation. Should be noted here that any individual or organization has the right to sue for libel except for governmental institutions. This is due to the First Amendment that gives the right to the citizens to criticize the government. But public officials has the right to sue for libels as an individual if they think that the defamatory language statements cause injury or actual damage. In all libel lawsuits, it's the plaintiff's responsibility to show the libel exists by proceeding to the courts that they have all the evidence for all the elements of the libel suit, or the courts will not allow the lawsuit to go forward. There are 6 standards of proof for a libel case. The first one is defamation. Defamation is an act of injuring another's reputation or a good name. The second one is identification. Many libel cases involving identification is because of naming a wrong person. The third one is publication. Publication is when the defamatory language was witnessed by a third party besides the 2 parties involved. For a non-media defendant, only one witness is necessary. But for mass media defendants, such as newspaper or TV station, the publication burden is presumed to be met. Publication can occur in public relations brochures, newsletters, or maybe conversations and interviews. The next standard of proof is fault. Fault means a mistake was made. This mistake could be an actual malice or an act of negligence. An actual malice means the defamatory statement was made with knowledge of it was false, while an act of negligence means that the defamatory statement was not made by a reasonable person, means that the defendant does not check the statements first, does not verify the statement first. The fifth one is falsity. Falsity means that the defamatory language is untrue, but this standard only applies to public figures or public officials. The last one is damage. Damage means that the defamatory language could hurt the plaintiff physically and mentally. By physically, it could financially harm the plaintiff. And also by mentally, it could cause the plaintiff emotional distress. So that's all from me. I will pass the presentation to the next presenter, which is Hanny. Thank you.
Thank you, Hannah. Now I will continue the presentation. The distinction between different forms of
Legal.
persons is crucial. This was done by the court to defend citizens' First Amendment right to free speech, ensuring that criticism of official government act would not be silenced. A subsequent Supreme Court case, Kurtz v. Welsh, distinguished between public figures and private figures as follows. Public officials are government employees who have or appear to the public to have substantial responsibility for or decision-making control in governmental affairs. They can be chosen or nominated. Public officials are not all government personnel, but only those who work in positions that are subject to more public scrutiny. For example, city tax assessor. Next, public figures. These are people who invite attention and comment and thus voluntarily expose themselves to an increased risk of public scrutiny and possibly to defamatory falsehood. Movie stars and athletes are examples of common public figures. Finally, private figures. The courts believe that private figures are more vulnerable to injury and can thus suffer more irreparable damage to their reputations. This is why private figures are held to a lower standard of fault than public officials and public figures. When charged of libel, a defendant has legal options both outside and inside the courtroom. A judge can issue a summary judgment in favor of the defendant before the case goes to court. This essentially implies that the case was dismissed because the plaintiff failed to fulfill the burden of proof in a libel suit. A libel action may also be dismissed outside of the courtroom due to a violation of the statute of limitations. This signifies that the plaintiff's window of opportunity to file a libel claim has passed. State statutes of limitation vary but normally range from 1 to 3 years. The law of privacy is divided into 4 thoughts by legal scholars, each of which is an interference with the plaintiff's right to be let alone. First, intrusion upon the plaintiff's seclusion or solitude, or into their private affairs. This thought deals with how information was collected, and the majority of these cases deal with the media's interference into people's lives. Second, public disclosure of embarrassing private facts about the plaintiff. This thought deals with information sharing regardless of how it was gained. Third, publicity that places the plaintiff in a false light in the public eyes. This can be accomplished by distorting or fabricating information in order to suggest that someone is not who they truly are, usually in an offensive manner. This topic of privacy law is closely associated with the law of libel. Lastly, appropriation, that is, the use of the plaintiff's name or likeness for the defendant's benefit without permissions. Invasion of privacy lawsuits include a number of legal defenses accessible to the defendant. The United States Supreme Court has acknowledged that the First Amendment protects the publication of some private information. The court has permitted the publication of the most truthful information collected legally from official government records or court proceedings. In stories of public interest involving public authorities or public figures participating in public proceedings, common law offers extensive protection for the publication of newsworthy material, and that newsworthiness overrides privacy rights. The newsworthiness defense also overrides the privacy interests of private individuals. Consent, which means that the defendant had permission to gather and disclose the information, is another defense in privacy violation lawsuits. Public relations practitioners who produce materials with information or photos of people often request that model releases be signed as a form of consent. The form must be written, state the names of all parties to the agreement, state the scope and duration of the agreement, and lastly, provide for consideration or payment. Practitioners must ensure that the proper individual signs the consent form, keeping in mind that children and people with mental disabilities are unable to offer legal consent. Bystander consent is implied in some situations, such as the filming of a YouTube video in a public park. If they do not consent to be in the video, they should move away from the filming area. That's all from me, so I will pass the presentation to the next presenter.
Online community and other internet platforms have given everyone a voice that is not limited by geography. The conversation that takes place on these platforms move fast-paced and can be unexpected. Clearly, technology hasn't rendered public relations absolute. It has only increased the ability of public relations professionals to engage with their target audiences. As social media is rising, so do the users. These include public relations practitioners. Their works across social media are important as their attitude also reflects of the company and their professional life as a PR. Here's a few recommendations on how to maintain your online reputation clean. First, post with caution. Even if your security settings are set on private, please assume that you publish everything online. Second, defend yourself. If someone has posted something about you and you find it to be offensive, request it to be removed properly. But if the person is refused, then please contact the service platform so that you may be able to comprehend this problem. Third, think long term. It is about think of how it will make you look like in 10 or till 30 years old ahead. 4. Patrol the web. Take a look at what people are saying about you. Set up Google alerts to notify you when your names appear on the internet. And then the last one is see it your way. Why? This is because when you consider the information or any image from the other party and you try to see it from a different perspective, you will see it different. In recent years, combining public relations and litigation has grown increasingly common, with the tendency growing year after year. Litigation PR helps to manage the process of communication throughout the course of legal dispute, which can highly impact on a person's reputation. For example, being sued isn't exactly a pleasurable experience. It can devastate a person's financial and emotional habits in any situation, but especially when that person is in the public spotlight. Unfortunately, lawsuits cannot be avoided. So litigation public relations is quite crucial when it comes up, especially for individuals whose reputations are on at risk. Litigation PR is always aiming for two things. The first one is to aid lawyers in influencing the outcome of criminal or civil court cases to the client's benefit, and the second one to shield the client from future damage to their reputation as well as the financial, and often became the company's challenge. So, what are the advantages of having the litigation PR? So the first one is the media dependency. Litigation PR practices are highly dependent on media reporting. While the general PR strategists can afford to keep media outlets as a side consideration, PR strategists must devote serious attention to how legal case can be perceived by the public outlets. Second one is the communication strategy. While hiring a reputable PR firm that specializes in litigation PR will help your company effectively to communicate with the key stakeholders during the unpredictable flow of the legal environment. The third, legal outcomes. As a result, litigation public relations professionally occupy a unique position in the communication field. They first must confirm their work does not breach with any contempt of the court regulations, and then before giving their final green light to the project. Although the public relations practitioner did not practice law, but the legal consideration often define and regulate in modern public relation practice. So as a result, having a solid understanding of the law will enable the practitioners to collaborate with the legal professionals so that the lawyers do not attempt to undertake the public relations work without their assistance. The public relation professionals are not immune to any litigation or loss, so that the growing needs for malpractice insurance is reasonable. The third one is that in today's media world, the practitioners must keep that in their mind that their behavior that they post, especially online, could have an impact on their professional life.